Morning, everybody. Welcome back to the Lateral Lawyers podcast. Just going to whip up a few little topics for you guys this morning to get back in the swing of things after a month of pretty hard graft. So, without further ado, the first topic I'm going to talk about this morning, is the new purchase price allocation rules. So, what this is about is the IRD's attempt to correct the situation where a vendor and a purchaser agree on purchase price under a sale and purchase agreement. They agree on the split of tangible and intangible assets and stock price, and then later submit different information which best suits their, which has the best tax efficiency for their particular entity. So the IRD is clearly getting mismatched prices or allocations of the purchase price. So what the IRD has said is from the 1st of July, they now have a rule is if you don't agree the mix of tangible and intangible assets or the portion of the purchase price allocated to those to the particular components of the assets that are being purchased. For example, if you're buying a business, you will have fixed assets, chairs, computers, in some cases attachments to premises, and then you'll have the goodwill portion, which may include the site location for a hospitality business, the remaining time under a license or a franchise agreement for a business with a license of fixed duration, and just general goodwill, which is usually extrapolated out of the multiple of the turnover. So you have all that, and now the rule is going to be that in instances where the vendor and purchaser don't agree to don't actually agree in writing to the allocation of the purchase price between those different portions, they're going to say that the vendor has a certain period after settlement to actually determine that, actually set out what the price is, and then that purchaser takes over. And then after that, an independent expert will fix the price. So, it's well-advised parties will always have that sorted out anyway, but you definitely, and recorded in the agreement, either at the time of signing of the agreement, or there will be a clause in there which says that the parties are to agree during due diligence. Personally, from a legal perspective, we would rather see it written in there at the beginning, but there are contingencies, and there are developments between parties once the accountants get their head around the full picture of the price and the value of the assets. There are going to be instances where it varies, but the more information you can have in there from the start, the better, in our view. It's going to be interesting to see what approach IRD takes. Obviously, for them to have actually created legislation around this shows that there must be getting a lot of mismatch information where people are suiting themselves or varying that purchase price after, the allocation of the purchase price after settlement takes place. So it's obviously enough of an issue for them to seek legislative change, and it'll be very interesting to see how they police that. Just building on that topic, the flavour of that topic is the inclusion of further terms of sale in general in sale and purchase agreements for either businesses or assets or property. So our view is that, particularly with property at the moment being such a hot market, is we're trying to encourage the party, whoever we're acting for, we're trying to encourage them to have a relatively minimalist sale and purchase agreement in the first instance. That's because assets and all types of asset classes are so hot at the moment. There's so much competition to get things under contract that vendors and agents acting for vendors will often push away offers from a purchaser which have too many clauses or look too tricky or look like there's too many obstacles to getting them unconditional. So as long as there's a due diligence clause in those contracts, we're in favor of having a relatively light contract. However, just a word of caution, things like the purchase price allocation I just spoke about, things like getting the real substance of the agreement in terms of what is included or isn't. For example, we acted recently on a spate of childcare centre purchases, and if you agree on 4 million, which is I think the price for one of them for all the assets, and you were labouring under the impression that there was 10 cars or vans included in the sale, and because they were in the fixed, you believed they were in the fixed asset register, and later turned out that they weren't. That broker provides it, as they often do, 5 working days, say, after the agreement's signed, and it turns out that those vans aren't in the fixed asset register. You're going to have a hard time prior to unconditional, even if the vendor has got a good price, to later say, for example, that there's $150,000 worth of vehicles were intended to be included, when the vendor says no, they weren't. Clearly, they weren't in the fixed asset register. We've entered into this agreement with you for 4 million. We're not adjusting the purchase price down by 150,000 because we never had any intention to sell you these vehicles. They were vehicles which are used personally by the staff. They can make up all sorts of baloney, to be honest. So with big ticket items, we want to see those covered off in detail at the beginning. But adding too many further terms of sale, adding too many wrinkles in there to the vendor at the moment, with the market the way it is, we've seen it's very hard to get agreements under contract. I'm just seeing what my last topic was for the morning. Okay, that really is it. But it talks about timing issues, as I've put in the headline, timing issues as well. So timing issues is essentially what we've just said, but I'll just say it a bit more clearly. So when you present an offer, that's for example, purchase of a business for a couple of million, and the agreement has very sparse conditions, and it has a due diligence condition, there may be a whole handful of things you want to get in there, but you shouldn't be bringing them up. If you can get the DD in there, bring them up when you can dangle the carrot by saying, look, here's our purchase price. We believe, based on the DD of the accountant and the lawyer, and we believe on various other factors which you would present to the vendor, that the price we're going to offer is 3.850. In return, we will satisfy the DD condition, but we would like these further clauses. Now, these further clauses may be a more detailed fleshing out of the tangible and intangible asset split. It may be a separate stock clause, because the one in the ADLS SPA can be problematic if the stock take isn't done prior to the handing over the money. There may be clauses around intangible depreciable property if it's a business with a license, such as a franchise license or just a license to use a branding. You may want something in there setting out that the parties agree it is intangible depreciable property under the Income Tax Act, so that you can, as the purchaser, then go and claim that is a depreciable expense over the life cycle of the business prior to settlement. You may want clauses in there giving further warranties, because the ADLS SPA has some pretty sparse, some basic warranties around what has gone on prior to the takeover. For example, if it is a business which has a couple of main contracts, you would want warranties in there that, alongside the fact that the contracts are in full force and there's no material breaches under those contracts, which a diligent purchaser would want to know about. There may be other problems that are separate to the contract that just haven't made their way into correspondence, such as the vendor has received notification that there is issues with the relationship. Maybe one of the key people that is a friend of the vendor is actually leaving the company, which has always been the relation person, or maybe it's even the person that was responsible for initiating the relationship with the vendor company is actually leaving. As you know, that can be a situation where there is a lot of risk. If someone in a major corporate account leaves, someone else comes in and decides, you know what, there's good competition here. I have no relationship anymore with Greg Smith at Infosystems Limited, and we're now going to hunt around and look somewhere else. So you really would want a warranty that the vendor has no knowledge of anything material that a diligent purchaser would want to know about that may affect the purchase price or just the business in general. So you've got to get good advice, you've got to come to somebody like us and make sure that you're actually working through all of these factors. Watch as many of these videos as you can. They're free. We like to think we give good value in them, and please reach out to me or Liam or Luella here at Lateral Lawyers. So it's lateralllawyers.co.nz. Give us a yell, and we can happily have a free consultation with you. If you're thinking about buying or disposing of an asset, come and see us, and we can give you tailored advice around that transaction. Thanks very much. It's good to be back in the saddle on video, and have a great day. Cheers.